and welcome to Know Your Rights. I am your host, Khadija Usher. On our show, you hear directly from attorneys who break down the law and explain the rights of citizens on common legal challenges that confront Belizeans on a daily basis. Tonight, we will be discussing the rights of employers and employees under our labor laws. You can watch us live on Channel 7 or on Facebook at Colorblind Multimedia Productions. You can also participate in the conversation by posting your comments or questions on our Facebook page or by emailing us at info@colorblind.bz. Joining us tonight to shed light on this very important topic is attorney Magalie Perdomo from Reyes and Retriege Law Firm. Good evening and welcome, Magalie.
Good evening, Khadija.
Labor laws. The labor law itself, it's very comprehensive. It's a very complicated topic and a very touchy topic for a lot of people. The law, when I went to research it, it's quite long.
Right.
It has so much information.
Right. Yeah, so the labor law actually evolves throughout time. Like as we all know, this started from slavery. So before, people would just work and they had absolutely no rights. It then moved into a situation where you had sort of apprenticeship systems, where some rights were afforded to workers, and then we evolve into what we have today, where a lot of people argue has gone full swing and workers have more rights than before now.
Okay, and I think a lot of times we say that the employees feel that it hasn't yet gone far enough, and the employers feel like it gone too far, would you say?
That's always the debate when you have an employer-employee situation. It's also important to know the sources of your labor law, because a lot of people tend to go to the Labor Act or to the contracts.
Okay.
And actually, many cases you have informal sources, such as your workplace policies, your collective bargaining agreements, and so especially for employers, it's always important to know that not just looking in the contract or what the labor law says, there might be things that would affect your workers' rights. And so if you end up in some horrible litigation or court case, you must know that certain things policies you put in place at work or customs that develop at work, you would be held liable for.
Customs as well.
Right.
So what you're saying is it's very important to not only be familiar with what we will be discussing here or what is in here, but your circumstance on a whole. When you are employed and you have a contractual agreement with your employer, and one of the biggest questions is, how can an employer terminate an employee?
Well, there are various ways. I would touch on the more popular and the more contentious issues that arise in termination. One is notice. So what the law provides is that employment relationship is essentially a contract.
Okay.
And you will not force people to be in a contract that they don't necessarily want to be in or it has broken down. And so what it provides for is that your employer can give you notice. So for example, and there's a range. So if you've been working at your job for between 2 weeks and 6 months, you must get 1 week notice. If you're there more than 5 years, you get your 8 weeks notice. And there's this idea which we call PILON, payment in lieu of notice, where as opposed to giving you the notice and having you at the job, they would then pay you the amount of your wages for that time frame.
So they have to do either or.
Yeah.
Either they tell you we no longer need your services,
or they can pay you off.
Or they can pay you off.
That's right.
But the payoff has to cover the same amount of time that the notice should have been there.
And it's also important to know that notice doesn't apply in cases where there's some sort of misconduct or dismissal in the workplace. That takes us into the next way that you can terminate an employee, and that would be for dismissal. And so if there's some misconduct, let's say for example theft, and you can prove that you found that in the workplace, then you can dismiss that employee without giving them notice. The law also provides for dismissing employees for good and sufficient cause. For example, constantly missing work or not having the skill that you undertook you had when you started working. And so those are ways in which you could terminate someone. Also, it's important that your labor law says what is not good and sufficient cause. For example, I cannot terminate someone because of their HIV status. I cannot terminate someone because of their religion or because of their union activities. So these things would never be good and sufficient cause. It's always important for employers to know that.
And the employers, they must provide proof of this cause, and I'm sure that they would have that to justify why they fire you. But if you, as the employee, feel that you were unlawfully dismissed, what is the process you go through, or who do you go to complain about this?
Well, most people start with going to the Labour Department and lodging an official complaint. You would write to your employee, and then after that, you would probably get legal action.
So the action, it has to go through the Labour Department, because and I'm asking the question because a lot of feedback that we got was that Labour slow, Labour not investigate properly.
Usually
is there another
people
route?
would go there, but if it is that you feel aggrieved and you've brought the issue up to your employer and nothing happens, then you can feel free to go to the court and lodge your claim.
Okay. And another area of interest is going into your working hours. Right. People are asking what is it that you're entitled to when you're working? Most of us are in a standard 8 to 5 and we get a lunch break. Is it by law that you must get this 1 hour lunch break? And also for people who are working, I guess, different hours.
So what the law provides is that if you're working over a period of a time frame of 6 hours, then you should get a 1 hour lunch break in the middle of the day. Right. But when it comes to shift workers, it doesn't necessarily apply, because you might have a shift starting at 11. It doesn't make sense for you to go on your lunch break at 12. And so for shift workers, that's an exception. But usually it's the 1 hour if you're working over a period of 6 hours.
1 hour. So you gotta work. Perhaps you do some janitorial duties, you go, you clean an office, and let's say from 1 to 5, they're not obligated to give you that. You just did like 5 hours.
Over your 6 hours, you must get.
Not obligated to give you lunch break. And what about overtime? How does the overtime situation work?
So overtime, anything over 9 hours in the day, if you're working more than 6 hours a week, and if you're working more than 45 hours a week, you're entitled to the overtime, which is a time and a half. If you work on your rest days, such as Sundays, you're entitled to your time and a half. Specific days, such as, for example, Easter Monday and Christmas, you get double right?
Time.
It's also important to know that overtime and these rates for overtime don't apply to persons who work in supervisory or management roles, persons who work on shift, persons who work on, let's say, agriculture and farms. You live on the farm, that's where you work. So there are some exceptions to that overtime rule.
Okay. I know I work with guys on shift, and we have a special way of sort of calculating it over a longer period, but we more go with them on based on hours work.
Right.
And also in that regard, we have to ensure that they get their proper time sleep, that they're not working maybe back-to-back shift, if it's 12 hours.
And so what the law looks at when it comes to shift workers, it looks at a period of 3 weeks.
Okay.
And so if you're doing the overtime, you're doing more than the 45 hours a week over that 3-week period, then you would be entitled to the overtime.
Okay. Can you refuse overtime work? It's a touchy situation.
Yes.
Especially, and I'm speaking from the perspective of my company. A lot of times we need to call guys out at very hours of the morning, hours of the day. Can you, as the employee, refuse it without any repercussions?
You're not obliged to work overtime, but if you do work, the law provides what benefits you're entitled to.
Okay. And the employer for overtime work, if you have an issue with your work hours or your work time, you don't feel like you're getting your fair due, does the law advise what your compensation should be, aside from the time and a half, or if you have an issue with the hours that you're working?
So your work, get paid based on your contract and what was agreed, and your minimum rates. The law sets what the minimum wage is. So outside of what is there for the overtime, then that is what you must pay to your employees.
You must follow. Okay, we'll go to a very short break. We'll be right back after these. Good evening and welcome back to Know Your Rights. I am your host, Khadija Usher, and we are here with Magalie discussing labor laws. So Magalie, we had a very good introduction on termination, as well as overtime and working hours. Under the labor law, what are the benefits that an employer is prescribed to give you as an employee?
Okay, so one of the most important ones that people talk about is, for example, their vacation benefits. And so what the law provides is that you're entitled to a total of 2 weeks for every year. So once you've been working there for a year, then you can get your 2 weeks vacation benefits.
For 1 year. You have to do that for a year before.
And it's always open to the employer and employee too. If they want to agree longer vacation, that's fine, but you must give 2 weeks within the year.
Okay, so let's go say I'm at my company for 5 years. The law doesn't say I kind of get bumped up more days, or I did it for 20 years. I know
you get
more.
your 2 weeks for the year.
Okay, so the law gives the minimum.
Correct.
But your employer can be more generous.
Definitely.
In terms of the other benefits, such as sick days, sick leaves.
Right. So for sick leave, you are entitled to 16 days sick leave.
16 days.
16 days sick leave, but you have to work at that particular job for at least 60 days for you to get your 16 days sick leave. And another important one is your maternity leave, because you always hear women complain, or it's always a peeve where they say, I've gotten pregnant and somehow I've been fired. And so the law protects you, and you cannot be fired for being pregnant. However, whether you will be paid or not while on your maternity leave is circumscribed by the law. So for you to get paid maternity leave, you must have been working at that job for at least 150 days. In other words, I can't start today and then tomorrow decide that, oh, I didn't mention to you that I was pregnant and I must now go on maternity leave.
Okay. And you said, you touched on that you cannot be fired during maternity leave or for being pregnant. I think it's a very serious issue, and I can identify with it because I'm in a technical field, and some of my job requirements is that sometimes I have to be in the field and in situations where I would not be or could not be if I am pregnant. So you're saying that the company can't lay me off because I can't fulfill those duties for pregnancy or...
Right. So you get your maternity leave. It's whether you will get paid or not on your maternity leave.
Okay, and you need the 150 days.
Right.
In terms of termination benefits, when we spoke on the 2 ways that you could be terminated earlier, under both ways, do you receive your benefits?
So if you have been terminated or dismissed for some sort of misconduct or for good and sufficient cause, you are not entitled to notice period because you've done something wrong. And so the law says, okay, you've essentially breached the contract, so we do not afford you the protection of someone that has been working at the job, doing what they're supposed to be doing. And so you're not entitled to notice, you're not entitled to the other benefits that the law allows.
So if you are caught and the employer, they have their evidence, they can come to you today and they can say, you're fired, get out, that's it?
Well, and that's an important thing too, because you always caution employers against acting too swiftly and acting out of emotion. You look at these shows like The Apprentice and you see you're fired, and those words could essentially be very costly to an employer, right? If you have an idea that your employee is doing something wrong, make sure that you have the correct information and make sure that the steps you take are in accordance with the law. I know not everybody can get legal advice. If you have a case where someone is stealing, obviously you want to get them out as quick as possible. But it's very important not to let that haste make you act in unlawful ways, because like I said, I cannot emphasize it enough. It can prove very costly to employers who act in an unlawful manner when terminating employees.
Okay. And as the employee, if you, once again, and we must reiterate, if you are dismissed and you feel that in the same way that we discussed that you felt that you are wrongfully dismissed, if you are dismissed and not provided your benefits, what is the process, or do you go to the same people to seek assistance?
Well, your first point would be to go to your employer and you raise the issue, you document everything. For unionized workers, you would go to your union, and there would always be a procedure that you can follow. That's why you have, for example, collective bargaining agreements, where it sets out procedures that protect workers who feel like they've been unfairly dismissed, for example. Or like I said, you go to the Labor Department and you make a complaint, and the Labor Department works as sort of a mediator between the employer and the employee. And the last port, obviously, would be to go to court.
Go to court. What about injuries on the job? How is that handled?
So, well, injuries on the job, there's a act which provides for a special law, which is called the Workmen's Compensation Act, which provides that if you are injured in the course of your duties or on your work, the law presumes that it's the employer would be responsible unless it can be shown otherwise. And so if you're injured on your job, you bring that to the attention of your employer, and then there's a procedure they must go through to compensate you. There are certain exceptions to that. For example, if you're injured on your job because of something you did wrong, or if it was some sort of pre-existing condition, then you would not necessarily be compensated under the Workmen's Compensation Act.
Okay. But as an employer, if I find myself in the situation that I got hurt, and my employer may not feel that it was my fault, and I feel that it was not my fault, it was a workplace hazard, what is necessary to prove that you were not at fault? You were in some hazardous environment at your work, and you want compensation.
Well, it's very important to get your medical records together as soon as possible, right? You don't want to leave things. So if you're injured, you don't wait a week, 2 weeks, a month before you actually get checked by a medical practitioner. So you need your medical records to prove the injury and the source of the injury, the reason of the injury. So that's the first thing that I would say that you need to do. Make sure you have your evidence and your documents together.
Okay. Go to a hospital, go to a clinic, go to somebody.
Exactly.
Get it before the time starts.
Correct.
In terms of Social Security, we receive a lot of questions when it comes to Social Security. There are some situations where the employer automatically deducts your Social Security, and they're supposed to give it to the Social Security Board. But how do you ensure that that is happening? Or is that your responsibility to make sure that is happening?
Well, that's a difficult one. That's a tricky one, because, you know, you're working there and you don't want to do anything. You know, you always have that fear as an employee that, you know, you go and report your boss and you lose your job. But it's your right that they must pay your Social Security payments, right?
Yeah.
So you would go and check at the Social Security office to ensure that these payments are made, and if they're not, then you would have to speak to your employer, or you inform the Social Security Department.
Do you find that employees, maybe from your experience, have been afraid to address this topic with their employers?
Many times, because a lot of employees don't even know their rights. You know, they're afraid, but you do have rights, and the law does protect you. And so if it is that you make a report, or you try to enforce a right like a Social Security benefit, it's not something that you could be dismissed for very easily.
And if you are, then you could go to labor.
Correct.
You could go through the proper procedures. We'll take another short break, but we'll be right back. And when we return, Magalie will be answering some of your questions that you sent in. We thank you for your questions and comments. We have selected 3 of your questions to ask our guest attorney. The first one comes from Charlotte. Charlotte wants to know, can your boss deny you a salary deduction to get a loan from a bank?
The law doesn't have there's no obligation on an employer to go through the administrative steps to ensure that your pay goes into a particular bank and ensure a salary reduction. It is something that is always done, but if it's not done, I don't know that you can actually have a legal right against your employer for not doing it. What the employer can do, though, is that if you are seeking to have wage deductions which are higher than 1/3 of your pay, so you're earning, let's say, $500 a month,
yes,
you can't have a $400 wage deduction. The law prohibits that.
Okay.
So there's a protection for the amount of wages which you must carry home.
Okay.
So in that case, an employer can clearly limit the amount of deductions that come out of your salary.
Okay, but in terms of them, as you started out saying that they don't have to do it, I guess that it comes from the perspective that
Right.
I just give you your salary and you
Correct.
do what you have to do with it, and they have all right to do
Correct.
something like that.
Correct.
Okay, and we can go to our second question. The second question is from Mikhail. Mikhail asks, when working for a company, can your employer request that you do work for which you do not have a license, like electrical work?
Absolutely not. So
Okay.
if the law requires that you must have a license to do certain activities, then you must have a license. Your employer cannot mandate that you act outside the law or that you work on things that you're not qualified to do. And so there's no requirement that they can have you work for doing something that you don't have a license to do.
Okay, and if for any reason the employer or the employee would feel that the employer is hold that against them, or that they face repercussions because of refusing to do that, they take up their claim once again with labor.
Right.
Or they can go to...
Or you could, go through the law.
The legal.
You would be protected.
And what about in instances, I know particularly with the electrical field where I'm in, there are certain times when the employees would tell you, well, I'm not comfortable doing this job because of this reason, or I have this type of illness that doesn't allow me to do the work, and so what about it in that instance?
So employers must be very careful with that, because even though it's a part of your job,
Yes.
if it is that the employee is telling you that there's something wrong with them or there's some reason that they cannot perform the job, you must look into that. The law provides, for example, for you to declare persons medically unfit. If someone is ill, can't come to work, can't do the job, you would then send them off to a medical practitioner to be checked. And if it is that the medical practitioner deems that they're unfit to continue working in the line of duties that they have signed themselves up for, then the person can be retired as being medically unfit for the job.
Okay. And our final question comes from Barris. Barris wants to know what constitutes sexual harassment in a workplace, and what measures would you need to take to fight your case in court?
Well,
loaded question.
That's a very loaded question that would have us here all night.
Okay.
So there is a Protection Against Sexual Harassment Act that we have here in Belize, which deals specifically with that, sexual harassment in your job.
Yeah.
And what the law says is that sexual harassment is where an employee feels that their prospects in their job or their working condition is contingent upon them accepting sexual advances or sexual innuendos by a boss. So if you feel like your boss or anyone else at the workplace is making these sexual advancements to you, and you feel you have to accept it, because if I don't accept it, I'm not going to get that promotion, or if I don't accept it, they're going to put me in the corner, the desk corner, and not provide. And so that is kind of what you look at when you're looking for sexual harassment. What is also important too is that if there is an issue of sexual harassment raised by an employee, employers must look into it, because what the law says is that if that is reported to you and you do nothing, you, the employer, will be liable as well. So it's very important to take these allegations of sexual harassment very seriously and deal with it.
And as a final wrap-up, Magalie, what are your final statements you want to say concerning the labor laws, concerning employers and employees?
Right. I want to repeat again, when it comes to employers, do not act on emotion. Don't act impulsively. Check the law. Know the sources of the terms of your working for your employees. And also as employees, know that you have rights, and it's not necessarily that you have to accept certain things. If it doesn't feel right, look into it, and you have rights.
Okay. And you have to know them.
Exactly.
So we have come to the end of our show for tonight. Thank you, Magalie, for joining us and providing so much information on tonight's topic. I am sure the viewers appreciated this discussion. Next Monday is a holiday, so Know Your Rights will be back on Monday, October 16th with attorney Aldo Reyes, who will discuss your rights pertaining to rental of property. Tonight's episode will be available for your viewing on Facebook and YouTube in case someone missed it. Thank you for watching and good night.